NCAA is having some major changes. You got NIL, you've got court rulings now having to pay players. I mean, it goes on and on and on. So as a result, the NCAA is constantly in court. They are under assault left and right. It's also from their own making. Okay, I mean, that's just what they've created this big problem because they were so arrogant and they were taking so much money and keeping it and paying big salaries. So in July, the U.S. Court of Appeals, the Third Circuit, rebuked the NCAA for what they call an offensive race-related argument in a case called Johnson versus NCAA, which compared college athletes. Listen to what I'm about to say, y'all. They compared college athletes to fellow students employed in work-study style programs. The NCAA argues that college athletes should not be treated with the same employee rights and protections as student ticket takers, student seating attendants, and student food concessions workers at NCAA contests. Instead, the NCAA relied upon a legal precedent comparing college athletes to unpaid prison labor under the 13th Amendment's slavery exception. Attorney Paul McDonald joins us right now. Paul, glad to have you on the show. I'm sorry, they used the slavery exception in the 13th Amendment? So are they saying that athletes are slaves or inmates?
Well, for all intents and purposes there, I think it's instructive to read exactly what the Third Circuit said. And this Third Circuit said, we disagree with the comparison of college athletes to prisoners and refuse to equate a prisoner's involuntary servitude as authorized by the 13th Amendment to the longstanding tradition of amateurism in college athletics. So that's exactly what the Third Circuit said about it. So they knew exactly what the NCAA was trying to do. They were using a case called Van Skyke v. Peters. And in the case Van Skyke v. Peters, I'm sorry if you lost me there for a second. You had federal prisoners who...
No, we got you. Go ahead.
All right. They had federal prisoners who said that under the FLSA, the Federal Labor Standards Act, that they should have employee rights, minimum wage, so on and so forth. But the court in that case, Van Skyke v. Peters, said because of the slavery exception, because as part of your conviction, as part of your sentence, you can be made to do an involuntary servitude, then you can't be an employee. And the NCAA for 10 years has been using that case, Van Skyke v. Peters, to say that athletes should not have employee rights like the kids selling popcorn at their games.
Well, first of all, for people who don't even realize, the phrase student athlete wasn't created out of, care for the student. That was actually created by an NCAA lawyer to protect them in a lawsuit. So they've always wanted to take advantage of the free labor of athletes and how everyone else gets paid except the athletes. So they've actually treated people as if they were, frankly, slaves under the 13th Amendment.
Right. Student athlete was a term that came about to avoid having to deal with worker compensation. Back in the day, before you had some of the safety equipment that you now have, you had even more injuries and even more deaths than you have currently. And so there was an issue of workers' compensation that came up. And so the whole term was created to try to suggest that the athletes were something other than employees. But again, the thing that people have to remember, there are student employees. There have been student employees on college campuses for more than 50 years in work-study style programs. So whether you're talking about someone who's checking IDs in the library, someone who is washing dishes in the dining hall, selling you things at the bookstore, or again, selling you popcorn at the games, all student employees. And all that our case is called Johnson v. NCAA. All we're saying is that athletes deserve to have at least the same limited student employee status as those fellow students. That's it. And the NCAA's opposition, again, is they know better. But the only way they can try to get beyond having the legal test applied is to make this incredibly offensive argument, especially when you consider how many brothers and sisters are responsible for much of what happens in the largest revenue generating sports. Right, we're about to go into March Madness. A large number of the stars we're going to be watching during the tournament are brothers and sisters, and they have the audacity to make this argument comparing athletes to prison labor on the slavery exception. Again, that's not an allegation. That's what the Third Circuit said in its opinion in our case last.
Well, it's interesting you say that. I mean, look, I graduated from Texas A&M University, and I actually worked for 2 years for the Texas A&M athletic department in its video lab. I was paid. I was a student, and I was paid working that. So the football players and the basketball players, all the other athletes in the athletic department, they didn't get paid, but I actually got paid for the work that I did. I was a student, so I mean, those things actually happen. But also, people just also need to understand that. Listen, the NCAA has been desperately. They've been ripping folks off, and this isn't just opinion. Who actually said that? The guy who used to run the NCAA, Walter Byers.
Right.
He wrote a book. He was the longest serving executive director, and he wrote a book laying out how the NCAA has been mistreating athletes since its inception.
Yeah, and it's what's interesting today. So now what they're trying to do, they're trying to go to Congress and get the Congress to give them some type of an exemption. Well, a couple of exemptions. The one that's really relevant to our case, they're trying to get an exemption to say that athletes can't be employees. Again, they know full well that there are student employees. So that exemption they're trying to get from Congress, frankly, violates the Equal Protection Clause, because you can't have two sets of students who essentially are the same. Arguably, athletes meet the criteria much more than the kids selling popcorn at their games, right? There's more control. I mean, I think people sometimes forget athletes are the most controlled students on any college campus. And another way of looking at it, consider this. An athlete has to schedule his or her classes around practice times, right? Whereas if you're in work study, your supervisor is required to schedule your work assignments around your class choices. It's a completely different situation. One, this work study student still gets academic benefits from the university. The athlete has academic burdens. Okay, so the athletes clearly meet the standard more. And so if you're going to try to single them out in legislation to say they shouldn't have these same rights, you have an equal protection problem. But the NCAA is trying to do that. They're also trying to get an antitrust exemption, which makes no sense. I mean, if antitrust exemptions made sense, then big tech, big pharma, big oil would have them. Instead, what they ought to do is acknowledge that these athletes are student employees and collectively bargain with them, just like anyone does in any other sport in this country. But they refuse to do that, at least so far.
That's because they're trying to protect that huge cash cow so they can keep making the huge, huge salaries.
I'm glad you brought that up, because one of the things they always say as to why they somehow can't give the athletes or recognize athletes should have the same rights as the students selling popcorn at the games or someone like yourself who worked in the athletic department. They try to say, oh, we can't afford it. Now, besides the fact they can't afford it is not a legal defense. It also happens to be untrue. Right now we have people talking about populism in politics, and people have different definitions of what that means, right? But at its core, I look at it in terms of how it's applied here, or should be applied here. You have coaches who are being overpaid. You have extravagant expenditures on facilities you don't need. And then, of course, the NCAA Division I, by their own reporting in fiscal year 2022, made $17.5 billion, billion with a B, second only to the NFL, more than the NBA, more than the Major League Baseball. And so they have the audacity to come in front of Congress and say, oh, we need you to bail us out because we can't afford to have these athletes making $15 an hour like their friends down the hall from in the dormitory, because it's going to bankrupt us. No, all you have to do is reallocate some of the money you've been giving to all the adults, reallocate some of the money you've been spending on laser tag and other things that are unnecessary in the athletic department, and then to the extent that you have smaller schools, after they've done all of that, subsidize them, just like the NBA does the WNBA, or you have luxury taxes in some pro sports. And that takes care of the problem. You can do all of this budget neutral, no cost. But they, to your point, they don't want to give up the big money they've made. Because I'm old enough, and I think you and I are probably comparable in age, I'm old enough to remember when college coaches didn't make all this money. Now you're talking about what Kirby Smart making $13 million at Georgia. If you cut his salary, 15%, you could afford to pay almost every athlete on that campus a fair wage that then would not require their parents to send them beer money on the weekends. And the one last thing I'll say about it, just so people understand this, what I'm talking about is not that the athletes would only be paid hourly wage. We're talking about base salary for everybody. If you still have individual popularity, you would get NIL on top of base salary. If you're in a sport that generates a large amount of revenue, you get revenue sharing going forward. So it's not an either or proposition. It is an and also.
No, indeed. Well, Paul, we certainly appreciate you joining us. Thank you so very much, and keep us abreast of what happens in this case.
Yeah, thank you, and good luck to everyone with your brackets. And just remember, as you're watching these games, that obviously are going to captivate us for the next 3 or 4 weeks, I guess. Just remember that they literally went there and said that the athletes are comparable to prison labor under the 13th Amendment slavery exception. They did that. Thanks.
Hello, I'm Isaac Hayes III, founder and CEO of Fanbase. And right now we're accepting investors in our $17 million round to revolutionize the future of social media. Today, for just $399, you can own 60 shares of stock in Fanbase at $665 a share. Go to startengine.com/fanbase and invest today. While the big platforms have grown too massive and disconnected from their users, Fanbase is building a platform where creators and users truly come first. We've already raised $8.6 million from everyday investors who believe in this vision, and now you can join them. This is your chance to invest in a social media tech company with over 1 million users that is disrupting media by allowing anyone to reach all of their following and monetize their content from day one. The market is changing, big platforms are failing to serve their users, and Fanbase is stepping up to fill the gap. Don't wait until it's too late. Invest now. Invest for yourself and your future. Go to startengine.com/fanbase and own the future of social media.